Well, I don't believe in suspense, so I will simply say before I start my formal judgment that we propose to allow the appeal from the decision of the Upper Tribunal and set aside, therefore, its decision and that of the FTT, and to dismiss the human rights appeal. The respondent in this appeal is a national of Bangladesh, born on the 18th of February 1989. He came to this country lawfully on the 7th of February 2016 as the spouse of a British citizen and was subsequently granted further leave to remain until the 14th of October 2021. On the 6th of November 2020, he pleaded guilty to a charge of rape and was sentenced to 6 years imprisonment. He was notified that the Secretary of State was minded to make a deportation order against him as a foreign criminal. In response, he made both a protection and a human rights claim. By decision dated the 3rd of October 2023, the Secretary of State refused those claims and a deportation order was made. The respondent appealed to the First Tier Tribunal under Section 82(1) of the Nationality, Immigration and Asylum Act 2012, I think, by a decision dated the 12th of December 2023, the First Tier Tribunal Judge Veloso, that's V-E-L-O-S-O, dismissed the appeal against the refusal of his protection claim, but allowed it as regards his dismissed the appeal against the refusal of his protection claim, upholding as part of that decision his exclusion from the protection of the Refugee Convention under Section 72 of the Act, but allowed it as regards the human rights claim on the basis that there was a real risk, if he were returned to Bangladesh, that he would suffer serious ill treatment on account of his political views and would accordingly suffer a breach of his rights under Article 3 of the European Convention of Human Rights. The Secretary of State appealed to the Upper Tribunal, but her appeal was dismissed by a decision of Upper Tribunal Judge Lane and Deputy Upper Tribunal Judge Hanbury, promulgated on the 29th of February 2024. This is the Secretary of State's appeal against that decision with the permission of Andrews LJ. She has been represented by Mr. Zain Malik, King's Counsel. The respondent has been represented by Mr. James Collins of Counsel, who also appeared in both tribunals below. We are grateful to both of them for their helpful submissions. The focus of this appeal must be on the decision of the First Tier Tribunal rather than the Upper Tribunal. I can summarise the judge's reasons as regards the Article 3 issue as follows. At paragraphs 28 to 43 of her reasons, she recites the evidence on which the respondent relied as showing that if he were returned to Bangladesh, he would suffer ill treatment. That evidence can be sufficiently summarised for present purposes as follows. One, it was his evidence, both in his screening and subsequent substantive interviews, and in his evidence to the tribunal, written and oral, that he had, since his student days, been actively involved in the student wing of the Bangladesh National Party, the BNP. At the date of the hearing in the FTT, the BNP had for many years been the main opposition party, the government being in the hands of the Awami League. That is no longer the case, but I will have to return to that later. For present purposes, we are concerned with, at this stage, we are concerned with the situation as it was at the time of the decision of the First Tier Tribunal. The respondent gave some details of the roles he had held, but he emphasised in particular that he had been active in the open quotes group, close quotes, of Ilyas Ali, a prominent BNP politician who disappeared in 2012 and is believed to have been murdered. Mr. Ali, quotes, would ask him to arrange meetings and gather people, close quotes. He produced photographs of himself in various BNP roles, including a photograph alongside Mr. Ali's wife. Since he had come to this country in early 2016, he had ceased to be a member of the BNP. Although he had attended some BNP rallies, he had not done so since 2018 or 2019. 3, he had returned to Bangladesh twice on a visit since he came to this country. The first visit was in 2017, when he had encountered no trouble of any kind. However, he had visited again in 2019 for his mother's funeral, on which occasion he had suffered an attack by Awami League supporters. At paragraph 30 of the reasons, the judge summarised the account given in his substantive interview as follows. Sorry, having taken that time to find it, I don't think I need read it out. The transcriber can read it into the reference. It's at paragraph 30 of the reasons at page 51 of the bundle. In continuing after that quote, in his oral evidence, summarised at paragraph 34, he said that after the attack he did not go back to the family home, but stayed in various other places until he could get a flight home. New para. A considerable part of this section of the reasons is concerned with evidence that the appellant was, or in any event had recently been, suffering from a severe depressive illness. This appears to have been regarded as important because the respondent relied on it as explaining why, in his substantive asylum interview, he had given various unsatisfactory answers about the extent of his role in the BNP. For reasons which will appear, however, I do not need to summarise this part of the evidence. The judge was also referred to the most recent Home Office, to the then most recent Home Office Country Policy and Information Note, CPIN, considering the political situation in Bangladesh, which dated from 2020. Section 2.4 of the CPIN is headed, quotes, risk, close quotes. It falls into two parts, paras 2.4.1 to 2.4.10, headed, open quotes, state risk, close quotes, and paras 2.4.11 to 2.4.17, headed, open quotes, politically motivated violence, close quotes. Broadly speaking, the former addresses persecution or ill treatment by state authorities, and the latter by non-state actors. Paras 2.4.7 to 2.4.8 read as follows. I won't read these out. They're to be found in the bundle of authorities at page 9. So it's paras 2.4.7 and 2.4.8. Section 2.5 is headed, quotes, protection, quotes, close quotes, and deals with the availability of state protection from persecution or serious harm. Unsurprisingly, para 2.5.1 says that where the risk in question is from the state, protection will not be available. But para 2.5.2 reads, I will read this because it's short, where the person's fear is of persecution and or serious harm from non-state actors, decision makers must assess whether the state can provide effective protection. Section 2.6 is headed, quotes, internal relocation. For our purposes, I need only note para 2.6.3, which reads, quotes, if the person's fear is of persecution or serious harm from non-state actors, such as supporters of rival political parties or factions within the same party, that threat may be localized. Relocation to another area of Bangladesh is likely to depend on the profile of the persecutor, as well as the facts of the case and the individual circumstances and profile of the person. At para 45 of her reasons, the judge refers to the CPIN. She quotes 4 passages, but the only one of those which I have noted above, which she quotes, is para 2.4.7. The judge's dispositive reasoning appears at paras 46 to 49 of her reasons, which I should set out in full, save that I omit a passage related to what I might call the mental health question. That, again, I will not read out now, but should be transcribed into the judgment. It appears in the bundle at paras 46 to at pages 55 and 56. So it's paras 46 to 49 from pages 55 and 56. In para 46, the words from the end of the 4th line, he remained, from the end of the 6th line, I'll start again, the passage starting in the 6th line, I find that his answers at interview, down to a few lines later, only its cause, can be omitted, just replaced by ... The Secretary of State appeals on 2 grounds as follows. The Upper Tribunal erred, quotes, the Upper Tribunal erred in upholding the First Tier Tribunal's decision because 1, the First Tier Tribunal's approach to the Article 3 claim based on political activities was legally flawed, semicolon, and 2, the First Tier Tribunal had erred in relation to the evidence concerning mental health issues. I start with ground 1. I am persuaded that the judge's reasoning in the crucial para 48 of her reasons is seriously flawed. The starting point must be that there was no evidence before her that the respondent was of any interest to the state authorities. The CPIN shows that the CPIN shows that the BNP had millions of members in Bangladesh who are not for that reason alone subject to ill treatment from the state authorities. Although the respondent was, on the evidence to some extent, an active member of the BNP, however precisely his activities for it should be characterized, whether generally or as part of Ilyas Ali's group, there is no suggestion that he was a high-level political figure, and the judge's findings went no further than that he had been, quotes, politically active, close quotes. See the beginning of paragraph 46. I note that there was no evidence that he had been stopped or checked in any way at the airport on his visits in 2017 and 2019. Such risk as the evidence demonstrated, and on which he relied, was from non-state actors, such as the Awami League supporters who were responsible for attacking him in 2019. But in the case of a risk of that kind, it is always necessary to consider the availability of state protection and the possibility of internal relocation. Those points were, as we have seen, expressly drawn attention to in the CPIN, but they simply reflect well-known legal principles in this area. The judge failed to address those possibilities at all. As appears from the end of paragraph 48, she simply said that, quotes, therefore, close quotes, i.e. as a result of her previous findings, neither state protection nor internal relocation were options. That is, with respect, a non sequitur. The 2019 attack was by local Awami League activists in the respondent's home area of Sylhet, S-Y-L-H-E-T, where, as the judge noted, he was known. Even if the view were taken that the police in Sylhet might not be prepared to offer realistic protection against such attacks, as to which I need express no view, it certainly does not follow that he would be at any risk of similar attacks if he relocated elsewhere in Bangladesh to an area where he was not known, most obviously, though not necessarily, to Dhaka. Mr. Collins was not able to offer any real answer to this point. He submitted that the focus of the argument in the FTT had not really been on relocation or sufficiency of protection. Even if that was so, as to which we are in no position to form a view, both were necessary aspects of the Article 3 assessment, and in the question of internal relocation, at least, featured heavily in the Secretary of State's decision letter. It was necessary for the judge to address that question with specific regard to the facts of the respondent's case. Mr. Collins accepted that whatever the degree of focus on the point in argument in the FTT, the Home Office presenting officer had made no concessions about it. The questions of sufficiency of protection and internal relocation are not addressed by the Upper Tribunal in the single short paragraph of its judgment, although the point had certainly featured in the Secretary of State's grounds of appeal and the reasons for the grant of permission by the First Tier Tribunal. It follows from that conclusion that the FTT's decision, and thus also that of the Upper Tribunal upholding it, must be set aside. Mr. Malik advanced some other arguments under Ground 1, including an argument that the First Tier Tribunal's decision that the respondent was at any risk on return was not open to her on the facts as found. But for reasons which will appear, I need not consider those points any further. nor indeed ground 2. The next question is whether we should remit the appeal to either the FTT or the UT, or remake the decision ourselves using our powers under section 14(2) little Roman 2 of the Tribunal Courts and Enforcement Act 2007. That decision is affected by a fundamental change in the circumstances underlying the respondent's human rights claim. In August 2024, i.e. after the decisions of both the FTT and the UT, the Awami League government was overthrown and replaced by an interim government under the leadership of Muhammad Yunus, who belongs to no political party. In December 2024, the Secretary of State issued a new CPIN. So far as relevant for our purposes, I need only refer to the executive summary, which contains the following statements. Leaders, members and supporters of political groups are unlikely to face persecution or serious harm from non-state or rogue state actors. Although politically motivated violence occurs, it has generally declined since the July and August protests. The number of people who are affected remains low in proportion to the size of the major parties. Leaders, members and supporters of the BNP, Jamaat Islami, that's Jamaat-E Islami Islami brackets JEL, and their auxiliary brackets student and youth close brackets organisations are unlikely to face persecution or serious harm from the state. Low-level supporters and members of the AL and auxiliary open quotes student and youth close quotes organisations, including a person who was simply a participant in a protest, are unlikely to be of ongoing interest to the authorities. Omitting a paragraph, in general, the state is able to provide effective protection to a person who fears a rogue state and/or non-state actor. The onus is on the person to demonstrate they would not be able to seek and obtain effective state protection. A person is likely to be able to internally relocate to escape persecution or serious harm by a rogue state and/or non-state actor where the threat is localized. Where a claim is refused, it is unlikely to be certifiable as clearly unfounded under Section 94 of the Nationality, Immigration and Asylum Act 2002. Mr. Malik submits that evidence is in practice incontrovertible and clearly establishes that the respondent, as a member and activist in the BNP, will no longer face any real risk of serious harm if returned. He submits that this court is in as good a position to make that decision as the UT or the FTT, and that we should do so. Mr. Collins' response was that the CPIN did not show an unequivocal picture. He noted that the passage quoted said only that it was, quotes, unlikely, close quotes, that BNP members or supporters would face persecution or serious harm from the state. And he drew our attention also to the final paragraph about the unavailability, or about the inappropriateness of certification. I'm afraid that is clutching at straws. It is quite clear that the term, open quotes, unlikely, close quotes, is used in this context to connote no real risk, and that is unsurprising in the context of the overthrow of the Awami League, from whom the feared risks would emanate. The remaining uncertainty, evidenced by the statement about certification, is evidently related to the possibility of some risk to Awami League supporters. And without going through the full text of the CPIN, one can see that, that, as I say, wholly unsurprisingly, that is the area where there is the possibility of some risks continuing. The truth is that the change of government has wholly changed the picture in such a way that there is no reason whatever to suppose that the respondent will be at serious risk if returned. I would, for those reasons, exercise our jurisdiction under section. I would, for those reasons, not only quash the decisions of the FTT and the UT, but exercise our jurisdiction to remake the decisions by dismissing the respondent's human rights appeal.
I agree.
I also agree.
Lords, I'm very grateful for the judgment. There is an application for costs, which is not opposed by learned friend. The amount claimed and as agreed between counsel is £17,296. I respectfully invite my lords to make an order requiring the respondent to pay that amount to the appellant. My lords, the respondent has the benefit of legal aid, and therefore the court's order, which we will agree and provide, will have the usual legal aid protection.
Very well. Nothing to say, Mr. Collins. No, thank you. Thank you both very much.